That's correct.
Yes, both you guys know that I'm very passionate about, well, most people know, I'm very passionate about certain things, and of course that's education. We do know about Lamar Grizzle versus the Board of Education that I have been totally attacked over for a year now. House Bill 251 and Senate Bill 84. Of course, it was declared unconstitutional by Judge Murphy in in Rome. I attended that with a temporary injunction. We're seeking a permanent injunction, of course, because we feel that our rights have been taken away, along with Judge Murphy. What do you see the future like? Because I heard that the state is appealing it. We met in mediation this past week saying that, would you please drop it and we'll live happily ever after. We're not going to drop it. It's unconstitutional. And we just want to know, what are y'all's take on this? How do you feel about it? Because it's just going to cost us, the taxpayer, more money. And I don't like it because I'm a taxpayer. What do you see about it?
Okay. Well, you open the can of worms, so we get down to it.
Yes, I'm sorry.
Okay. The school board wasted $15,000 fighting.
Whoa. No talking over. Okay. Start the time over, please.
Okay, sorry. I totally disagree with your comments. And that's right that we all have. With what you said, the school board wasted $15,000 of taxpayer money supporting a personal lawsuit.
Wait.
I'm sorry, I'm listening, but
the state constitution states that the General Assembly is responsible for establishing the election criteria for local governments. It even exempts it from the home rule portion of the Constitution. We do not allow local governments to set their own election criteria because it's a conflict of interest. The judge did not rule it was unconstitutional. He put a temporary injunction so he can go and look. Now, he didn't rule, he basically said it was not unconstitutional from the state constitution. He agreed that the General Assembly had the ability to state that you cannot be a school board member if you have an immediate family member serving in an administrative role in the local school systems. What I read was that he ruled that he's still looking at the First and 14th Amendment, which there's already been 3 U.S. Supreme Court decisions that have ruled that the First Amendment does not give somebody the right to run for office. That is not under the Freedom of Speech Act. The temporary injunction just said that Chairman Grizzle cannot be barred from running for re-election. But I've had attorneys, when that lawsuit came out, I took it to some of the top attorneys, even legislative counsel, they all agreed that that lawsuit was not on behalf of the school board, but it was a personal lawsuit because the plaintiff in there doesn't even live in Bartow County. It's 2 personal lawsuits. In my opinion, the school board, and I asked for the Attorney General for official opinion. He couldn't write one, but because he's a defendant, but he did give me case law saying that the school board very well may have violated federal and state laws by spending education money on a personal lawsuit.